The following program was produced by the United States Courts.
Hello and welcome to our program. I'm Krista Rubin and I'm joined today by Rachel Pierce. And in collaboration with the FJC, we're happy to be here to present to you the Sentencing and Guidelines 2009 amendments. Now, as the title indicates, today's broadcast focuses on the most recent changes to the U.S. Sentencing Commission Guidelines Manual. And these amendments went into effect on November the 1st, 2009. And for those of you who are still awaiting your copy of the new Guidelines Manual, here's a sneak peek at the color for this year. Our goal today is to provide you with a greater understanding of the application of these new amendments. And we're going to do that by discussing the background and the application as well. But before we get started on our review of those specific changes, let's just briefly go through some housekeeping items. First, our program-related materials. On the FJC's DCN site, which you can see at the bottom of your screen, you will find a link to the materials for today's broadcast. First, we have a copy of the slideshow that Rachel and I will be using for today's broadcast. Secondly, we're also providing you a link to the reader-friendly version of the amendments to the sentencing guidelines. This is a very useful version of the 2009 amendment changes. Deleted language appears as struck through. New added language appears as highlighted. So it's a really great reference if you're looking for the change and finding that quickly. For the official version of the amendments, however, please look to the new Guidelines Manual that contains the amendments effective November 1st of 2009. And our new manual can be accessed on the Commission's website at www.ussc.gov, as you can see there. For those of you who are interested in obtaining CLE credit for this broadcast, please also look to the FJC's DCN site for that information. Now on to today's agenda. First, we're going to start with a quick review of the amendment process, the process the Commission goes through to promulgate amendments. Then we'll move on to the 2009 amendments themselves. And then in our final segment, we will have time to turn our attention to any questions from you, the viewers. Now, as detailed in the announcements for this broadcast, we have been and are still accepting any questions you may have on the 2009 amendments. One way you can get those questions into us is to fax them directly into the studio, and you can see that number on the bottom of your screen, and we'll show you that periodically throughout the broadcast. Besides faxing in your questions, you also have the ability to email directly into the studio any issues you would like us to touch on regarding the 2009 amendments. So whether you're at your PC or if you have your BlackBerry handy, you can shoot us a quick email and we'll do our very best to answer those questions at the end of the broadcast. So if you have any now, please send them in. If you have any throughout the duration of the broadcast, please send them in as they come up. Let's take a closer look at the amendments we're going to be discussing today during the broadcast. We're first going to spend time addressing amendments related to offenses involving identity theft. Next, we'll talk about the amendments related to drug offenses. Then, we'll address some amendments that address various other congressional legislation, and both the identity theft and drug offenses amendments are the result of congressional legislation, as we'll discuss a bit later on. The next segment of the program will review the amendments that resolve circuit case law issues, and then we'll briefly touch on other pertinent miscellaneous and technical amendments. But before we begin our discussion of the specifics of the 2009 amendments, let's talk a little bit about the amendment process itself. Specifically, Rachel, let's first discuss the Commission's authority for promulgating amendments to the sentencing guidelines.
All right, well, Krista, to discuss the Commission's role in the promulgation of amendments to the guidelines, we really need to turn our attention to the Commission's organic statutes, which are found in the United States Code at Title 28, Sections 991 through 998. So let's take a look at the specific provisions focusing on the United States Sentencing Commission's amendment cycle, which is at Title 28, Section 994-0. This provision provides the Commission the authority to periodically review and revise the guidelines promulgated pursuant to the provisions of Title 28 in consideration of comments and data the Commission receives and reviews. Section 994-0 of Title 28 also provides that the Commission considers input from authorities on and individual and institutional representatives of various aspects of the criminal justice system. And as you can see, these authorities and representatives include the U.S. probation system, the Bureau of Prisons, the Judicial Conference of the United States, the Criminal Division of the Department of Justice, as well as a representative from the federal public defenders. In addition, the Commission also receives comment from other interested groups and individuals. The Commission considers the comment received on the guidelines during the amendment process. Also, as part of this process, the Commission will look to its comprehensive and informative data.
Now, Rachel, let's talk just a little bit more specifically about this process, how the Commission receives and uses this information, and also the time frame that's used to do this.
Sure. The amendment process begins each year with the Sentencing Commission publishing their proposed policy priorities in the Federal Register. These priorities detail the issues and guidelines that the Commission is considering for the upcoming year. Persons who are interested in the guidelines are able then to provide public comment on these proposed priorities. After consideration of the public comment received, the Commission then votes on these proposed priorities and submits a list of final priorities for publication in the Federal Register. Based on this list of priorities, and while also being mindful throughout this process of any congressional legislation that may be enacted, the Commission begins the amendment process of reviewing information and data related to these issues. As a result of this research and consideration, the Commission finally publishes the proposed amendment language in the Federal Register. Again, persons who are interested in the guidelines are provided the opportunity to provide public comments, this time on the proposed amendment language. The Commission then continues to review and examine the issues, consider any additional public comment, and analyze the data as they relate to these final priorities. Oftentimes, the Commission will hold public hearings if there are issues of interest and they want to get the public's input on the proposed priorities or the proposed amendment language and the issues that they're addressing. The culmination of this amendment process occurs when the Commission votes on the final amendment language that is to be included in, ultimately, the Guidelines Manual. Then by May 1st of every year, the Commission submits to Congress this proposed amendment language to the sentencing guidelines.
And Rachel, going back to our organic statute, at Title 28, Section 994P, this enabling legislation addresses this submission to Congress. The statute provides that no later than May 1st of each year, the Commission shall submit amendments to Congress for review. The statute also states that if Congress does not affirmatively modify or disapprove the amendments within 180 days, that is up until November 1st of that year, the amendments automatically take effect on November 1st unless Congress passes legislation to the contrary. Now, all of the amendments we're going to be talking about, all of the amendments from this year, followed this process that Rachel has just outlined. And as most of our viewing audience knows, sometimes there are amendments that go into effect on dates other than November the 1st because Congress grants the Commission emergency amendment authority to promulgate a change to the guidelines within a particular time frame. None of the amendments this year were subject to any congressional directive granting the Commission emergency amendment authority. So with the understanding that all of these amendments went into effect on November 1st, 2009, and now that we've reviewed the Commission's amendment process, let's focus specifically on the background and application of the amendments themselves. Now, perhaps the amendment package that may affect the greatest number of defendants sentenced under the guidelines is the amendment package addressing offenses related to identity theft. So the primary changes you will see regarding this guideline, or regarding this package of amendments, is found in Guideline 2B1.1, the Fraud and Theft Guideline. There were other changes made to 2H3.1, which is the guideline addressing interception of communications and eavesdropping. And then finally, there's a change in 3B1.3, the Chapter 3 adjustment that addresses the abuse of a position of trust and use of a special skill. Now, the reason that these amendments may affect a large number of defendants is primarily because we see changes in 2B1.1. And in fiscal year 2008, we know that 2B1.1 was used nationally on average to calculate over 10% of federal cases. So potentially there could be some significant impact as a result of this amendment package.
Now, Krista, before we get into the actual language that the users will see in the guideline manual, let me just give a little bit of background on the legislation and some of the directives that the Commission had. In 2008, Congress passed the Identity Theft Enforcement and Restitution Act, which provided the Commission with directives to review the guidelines applicable to persons convicted of offenses under specific statutes that were referenced, and any other relevant provisions of law in order to reflect the intent of Congress that such penalties be increased in comparison to the penalties provided at the time the legislation was passed. Now, you can see from our next slide here that the specific statutes involve offenses of conviction relating to the unlawful dissemination, use, or access to personal information. You can see 18 U.S.C. Section 1028 deals with document fraud offenses. 18 U.S.C. Section 1028A deals with aggravated identity theft offenses. 18 U.S.C. Section 1030, that's where you're going to find your computer fraud offenses. 18 U.S.C. Section 2511 deals with eavesdropping types of offenses. And finally, 18 U.S.C. Section 2701, which deals with unlawful access to communications, as these are the specific areas of concern that Congress identified. In addition to that, the public law also provided for that the Commission consider 13 factors in order to create a defective deterrent for these types of crimes. And you can see some of the 13 factors listed here. That is the using of a protected computer, the privacy rights of individuals, offenses involving proprietary information and how to determine loss in those cases, the intent to obtain or disclosure of personal information, as well as closely looking at the definition of victim as defined in 2B1.1. So the first issue that we'll address is relating to both a listed statute in the directive as well as one of those factors, one of those 13 factors that the Commission needed to consider. And as a result, the Commission has added an additional specific offense characteristic to the general fraud and theft guideline at 2B1.1. The new specific offense characteristic, or SOC, as we'll use, I'm sure, through the rest of this broadcast, is located at subsection B15. This new SOC will apply in cases under 2B1.1 where A, the defendant was convicted under 18 U.S.C. 1030, which is the computer fraud statute, and the offense involved an intent to obtain personal information, or B, where the offense involved the unauthorized public dissemination of personal information. So a couple of things I want to address when we talk about this specific offense characteristic. First, it's an either or. It's an A or a B. And there's a difference in these two subsections of the specific offense characteristic. The A subsection requires a specific offense of conviction, and that is the 18 U.S.C. 1030 offense of conviction. So not only that specific offense characteristic, but also the an intent to obtain personal information. The second half of that offense characteristic does not require a certain offense of conviction. So it's a relevant conduct analysis. So if the offense involves the unauthorized public dissemination of personal information, that's a 2-level increase. Difference between offensive conviction based versus relevant conduct analysis. The second thing I want to point out is that it's an either or determination here. So you may have a situation where both would apply, but it's only a 2-level increase. Either A or B is going to provide you with that 2-level increase. Application of the specific offense characteristic, of course, relies on the definition of personal information, which can be found in Application Note 1 of 2B1.1. Personal information is defined as sensitive or private information involving an identifiable victim, including medical records, wills, diaries, private correspondence, which includes email, financial records, photographs of a sensitive or private nature, or similar information. So as you can see, the specific offense characteristic will potentially apply in a number of cases, and a lot of the cases that we typically see as identity theft type cases, this specific offense characteristic could apply. So it's going to reach probably a broad range of offenses.
Absolutely. And another significant change to the 2B1.1 guideline as part of this identity theft amendment package addresses the definition of victim as it's defined at 2B1.1. Now, related to this definition is the specific offense characteristic you see on your screen, specific offense characteristic B2. Now, this SOC is not new to the fraud guideline. It has been around for a number of years. But what we're interested in is the definition of victim as used in the application of this specific offense characteristic. It is one of the factors the Commission was directed to consider as part of the Identity Theft, Restitution, and Enforcement Act, but also has been the subject of various circuit court case law decisions. And you can see the SOC provides increases of either 2, 4, or 6 levels, depending upon the number of victims involved in the offense. Now, victim, as it's referred to in this specific offense characteristic, has long been defined as 1, any person who sustained any part of the actual loss determined under subsection B1, which is the loss table, or 2, any individual who sustained bodily injury as a result of the offense. Now, effective November 1st, 2009, we have an additional criteria in this definition of victim, and this applies in cases involving means of identification. Not only is a victim any person who sustained any part of the actual loss, or any individual who sustained bodily injury as a result of the offense, but for cases involving means of identification, any individual whose means of identification was used unlawfully or without authority is also considered to be a victim for the purposes of specific offense characteristic B2. Now, means of identification is also defined in the guideline in Application Note 1 of 2B1.1. The definition states that means of identification has the meaning given the term in 18 U.S.C. 1028 D7, except that the means of identification shall be of an actual individual other than the defendant or a person for whose conduct the defendant is held accountable under 1B1.3, which is the relevant conduct analysis. So this is a big change in the definition of victim for the purposes of 2B1.1.
That's right, Kristen. Another component of this identity theft amendment package is the addition of a factor for the court to consider when estimating loss in cases involving proprietary information or trade secrets. In a case involving this type of conduct, the court may consider, for the purpose of estimating the loss amount, the cost of developing that information or the reduction in the value of that information that resulted from the offense. For example, let's say we have a defendant who is a disgruntled former employee of the Coca-Cola company. And so as a result of his anger from being terminated, he takes the secret for Cherry Coke and he sells it to the Pepsi-Cola company. The court now can consider the potential lost revenue that the Coca-Cola company may have as a result of this defendant's action in determining the loss in such a case involving this proprietary information or trade secret. Now, in response to directives contained in the Identity Theft Enforcement and Restitution Act of 2008, the Commission also amended the guideline at 2H 3.1, which is the Interception of Communications Guideline. As a conforming change, definitions of means of identification and personal information were added to Application Note 4 at 2H 3.1, which are consistent with the definitions as they appear at 2B 1.1. Upward departure language was also added to Application Note 5 to include an offense involving personal information or means of identification of a substantial number of individuals. This departure factor encourages the court to consider the increased harm involved in the unlawful access or use of personal information of a substantial number of victims. Finally, as part of this identity theft amendments package, the Chapter 3 adjustment for abuse of position of trust or use of a special skill, which is found at 3B 1.3, was modified specifically at Application Note 2B. The application note now specifies that a defendant who exceeds or abuses his or her authority in their position in order to obtain, transfer, or issue unlawfully or use without authority any means of identification shall be subject to this enhancement. And the change there is the insertion of the language of transfer or issue. So a defendant who is using or abusing their authority in transferring or issue means of identification is subjected potentially to this enhancement at Chapter 3. So as you can tell, we have made some substantial changes to the guidelines as they relate to identity theft offenses. But now it's time to move on to our next topic, and that is relating to amendments relating to drug offenses. There are two sets of amendments that we're going to discuss today that resulted in changes to the drug guideline, if you will, at 2D 1.1. Both of these amendments were in response to congressional legislation.
That's right. And so the first one we're going to discuss today stemmed from congressional legislation addressing online pharmacies. Guideline 2D 1.1 is primarily affected by these amendments, although the minor changes were made to Guideline 2D 3.1 as well, as we'll talk about. Now, the name of the act is the Ryan Haight Online Pharmacy Consumer Protection Act of 2008. And what it did initially, of course, was create two new offenses. At Title 21 of the U.S. Code, Section 841H, that statute addresses offenses involving dispensing controlled substances by means of the Internet. The statutory maximum terms of imprisonment vary depending upon the type of the controlled substance that was involved in the offense. The applicable guideline for this new offense is 2D 1.1. The other new offense created by this legislation is found at Title 21, Section 843C2A of the U.S. Code, which prohibits the use of the Internet to advertise for sale of a controlled substance. This new offense has a statutory maximum term of 4 years, and this new offense is referenced to Guideline 2D 3.1, and the title of that guideline was amended to include this new offense. So that's the minor change to 2D 3.1. Now, the Ryan Haight Online Pharmacy Consumer Protection Act of 2008 also increased the statutory maximum penalties for all Schedule III and IV controlled substances and for second and subsequent offenses involving Schedule V substances. The Act also added to the statute a sentencing enhancement for Schedule III controlled substances where death or serious bodily injury resulted from the use of such substance. Now, to address these new statutory sentencing enhancements, the Commission added 2 new base offense levels to the drug guideline at 2D1.1. As you can see from this slide, the first is found at base offense level A3 and provides for a base offense level of 30 if the defendant is convicted under 21 U.S.C. 841b1e or 21 U.S.C. 960b5, and the offense of conviction establishes that death or serious bodily injury resulted from the use of the substance, and the defendant has a prior conviction for a similar offense. This base offense level is offense of conviction based. It is not applied based on your standard relevant conduct analysis that you find at 1B1.3. Now, similarly, and in addition, the other new base offense level can be found at 2D1.1A4, and it provides for an offense level of 26 if the defendant was convicted under 21 U.S.C. 841b1e or 21 U.S.C. 960b5, and the offense of conviction establishes that death or serious bodily injury resulted from the use of the substance. Now, remember also that with these additions, these new additions to 2D1.1 at the drug guideline, the base offense level that is used most often, that is the one that refers to the drug quantity table, has now been moved. So the site for that particular base offense level now is 2D1.1A5. So don't forget to change your PSR macros to reflect this new amendment to 2D1.1. Now, as we mentioned just a short time ago, the Online Pharmacy Act increased statutory maximum penalties for Schedule III, IV, and V controlled substances. The directive to the Commission included in this legislation stated in part that the Commission should not construe any change in the maximum penalty for a violation involving a controlled substance in a particular schedule as being the sole reason to amend or establish a new guideline or a policy statement. The Commission carefully considered this matter and did not make any changes other than those specifically directed by Congress. So the final change addressing this Online Pharmacy Act legislation involves drug trafficking offenses involving Schedule III Hydrocodone. Schedule III hydrocodone substances, or Schedule III substances in general, I should say, are subject to a base offense level of 20. That is the maximum base offense level that can be used for Schedule III substances. However, effective November 1st of this year, the Commission raised the maximum base offense level for Schedule III hydrocodone from a base offense level of 20 to a base offense level of 30. The Commission determined that a maximum base offense level of 30 is appropriate for this particular controlled substance because of data and testimony indicating a high prevalence of misuse when compared to other non-marijuana drugs of abuse, an increasing number of emergency room visits involving this drug, and the very large volume of hydrocodone pills that are illicitly distributed either over the internet or sometimes in the specialized pain clinics. Also, I would like to note that Schedule III hydrocodone has been added to the drug quantity table itself, so you will see that change reflected as well.
Now, Krista, the second set of amendments to the drug guidelines were also resulting from congressional legislation. The Commission amended 2D1.1 and created a new guideline at 2X7.2 in order to address this legislation. And that legislation is the Drug Trafficking Vessel Interdiction Act of 2008. And this act created a new offense at 18 U.S.C. Section 2285, which is the operation of submersible vessels or semi-submersible vessels without nationality. This new offense carries a statutory maximum penalty of 15 years. These offenses involved criminal cartels building and launching submarine-like vessels to use in the transportation of contraband. Mm-hmm. Testimony before the Commission indicated that to date, these vessels have been used to transport enormous quantities of controlled substances. So far, these cases have only been prosecuted in 1 or 2 districts, but just in case you see one of these cases, I'm of course going to explain it further for you. The directive to the Commission required that in the promulgation of these amendments that the Commission provide penalties for persons convicted of this new offense, to consider various factors in doing so, including the relative serious nature of the offense, as well as aggravating and mitigating circumstances. Some of these aggravating and mitigating circumstances include the actual use of the vessel, failure to heave to when directed by law enforcement, in this case the Coast Guard, and other relevant statutes and provisions. So the Commission addressed this legislation in 2 ways. First, the Commission expanded the scope of the specific offense characteristic at 2D1.1b2 by adding a new subdivision at B2b. This new subdivision applies in a case in which the defendant unlawfully imported or exported a controlled substance under circumstances in which a submersible or semi-submersible vessel was used. This conduct, as you can see, is going to result in a 2-level increase with a minimum offense level of 26. So just as a reminder, we often call that a floor of 26, so that when you're going through your guideline application and you add these 2 levels, if you're not already at a level 26, then this will send you to or bump you up to a level 26. Second, to address actual convictions under this new statute at 18 U.S.C. Section 2285, the Commission created a new guideline at 2X7.2 entitled Submersible and Semi-Submersible Vessels. As you can see on this slide, this new guideline provides a base offense level of 26, which is the offense level that's comparable to the enhancement that we just talked about at 2D1.1, that floor of 26. This new guideline also contains a specific offense characteristic at B1. This SOC provides for an increase of 2 levels if the offense involved a failure to heave to, an increase of 4 levels if there was an attempt to sink the vessel, or an increase of 8 levels if the vessel was actually sunk. Many times what happens in these offenses is that when the Coast Guard responds to this vessel that's out of the waters it should be in without any markings, defendants on the vessel actually attempt to sink it, and so it becomes a rescue mission for the Coast Guard. And so the concern obviously is that these are very dangerous offenses, potentially very dangerous offenses. And so the Commission felt like it was important to respond in the way that it did to this congressional legislation. Additionally, the new guideline at 2X7.2 contains some upward departure provisions. An upward departure is warranted in a case in which the defendant engages in a pattern of activity involving the use of submersible or semi-submersible vessels to facilitate other felonies. An upward departure may also be warranted where the offense involved the use of the vessels as part of an ongoing criminal organization or enterprise.
Thanks.
Sure.
So we've talked about 3 congressional legislation amendments, and we're going to move on now to talk about other amendments that are addressing congressional legislation. So Congress in late 2008 passed legislation addressing crimes of alien harboring committed in furtherance of prostitution. Corresponding changes have been made in the Alien Smuggling Guideline, which is at 2L1.1, the Fraud Guideline under 2B1.1, and the Peonage Guideline 2H4.1. The act prompting these amendments is the William Wilberforce Trafficking Victims Protection Reauthorization Act of 2008. The directive to the Commission in this public law required the Commission to review and amend, if appropriate, the sentencing guidelines applicable to persons convicted of alien harboring to ensure conformity with the guidelines applicable to a person convicted of promoting a commercial sex act if the harboring was committed in furtherance of the prostitution and the defendant is to be sentenced as an organizer, leader, manager, or supervisor of the criminal activity. In addressing this legislation, the Commission has added a new specific offense characteristic at 2L1.1B8B. A 2-level increase will apply to a defendant convicted of alien harboring, where the alien harboring was for the purpose of prostitution and the defendant receives an adjustment under 3B1.1, the Chapter 3 adjustment for aggravating role in the offense. If the alien engaging in the prostitution behavior, however, is under 18 years of age, the enhancement increases to 6 levels instead of 2. The Wilberforce Act also created 2 new offenses. The first, fraud in foreign labor contracting, is found at Title 18, Section 1351, and is referenced to 2B1.1, the fraud guideline. The other new offense, benefiting financially from peonage, slavery, and trafficking in persons, is found at Title 18, Section 1583A, and is referenced to Guideline 2H4.1. The Commission also made some corresponding modifications in the peonage guideline, the 2H4.1 guideline, to address the new offense under Section 1593A of Title 18. First, a new base offense level at subsection A2B provides a base offense level of 18 if the defendant was convicted of an offense under 1593A that's based on an act in violation of 18 U.S.C. 1592. The Commission also added some downward departure language to 2H4.1, which can be found at Application Note 4. So in a case in which the defendant was convicted under Sections 1589B or 1593A under Title 18, and the defendant benefited from participating in a venture described in those sections without knowing that is, in reckless disregard of the fact that the venture had engaged in the criminal activity described in those sections, a downward departure may be warranted.
Now, Krista, the final amendment that addresses congressional legislation is actually a continuance of the work that the Commission has done in the past in response to the Court Security Improvement Act of 2007. The Commission passed a number of amendments effective November 1st of 2008 in response to this legislation. And the Commission, again, in this past year, continued its work in that area with the promulgation of additional amendments to 2A 6.1, which is the Threatening Communications and Harassing Communications Guideline. As you can see from this next slide, the directive to the Commission addressed in this amendment is the instruction to review certain threats made in violation of Section 115 of Title 18 of the United States Code, specifically those threats that occur over the Internet. Violations of 18 U.S.C. Section 115 involve influencing, impeding, or retaliating against a federal official by threatening or injuring a family member. The directive also provides factors to take into consideration during this review. They include the number of threats made, the number of intended recipients, and whether the senders of the threats acted alone or were part of some larger group. The amendment adds a new specific offense characteristic to the guideline at 2A 6.1, specifically at 2A 6.1 subsection B5. Let's take a look at this 2-level increase. If the defendant A is convicted under 18 U.S.C. Section 115, B made a public threatening communication, and C knew or should have known that the public threatening communication created a substantial risk of inciting others to also violate that same section of the statute, then the 2-level increase is going to apply for that defendant. Additionally, the Commission, in response to this legislation, amended Appendix A to provide additional guideline references for violations of 18 U.S.C. Section 1513, which is retaliating against a witness, victim, or informant. The additional references, as you see, to the murder, manslaughter, assault, and property damage guidelines more adequately reflect the range of conduct that is covered by this statute. This change also corresponds to the guidelines referenced in Appendix A for violations of 18 U.S.C. Section 1512, which is the tampering with the witness, victim, or informant, which obviously covers a similar range of conduct. Now, moving on to the amendments that address the case law issues. These amendments are the results of Commission initiatives and respond to specific application issues that the Commission has elected on its own to resolve. Krista, would you like to get us started?
Absolutely. The first amendment we're going to be talking about is a specific offense characteristic found in 2A3.2, the statutory rape guideline, and 2G1.3, the travel to engage in illicit sexual conduct with a minor guideline. Now, both of these guidelines contain a specific offense characteristic that applies if a participant otherwise unduly influenced the minor to engage in prohibited sexual conduct. Now, the commentary in both of these guidelines states that in determining whether this undue influence enhancement applies, the court should closely consider the facts of the case to determine whether a participant's influence over the minor compromised the voluntariness of the minor's behavior. Now, in both guidelines, the term minor is defined to include an individual, whether fictitious or not, who a law enforcement officer represented to a participant could be provided for the purposes of engaging in sexually explicit conduct, or an undercover law enforcement officer who represented to a participant that the officer had not attained the age of majority. Now, the crux of the issue is in this commentary, and there is a circuit conflict on the application of the undue influence enhancement that has been resolved by this amendment. 3 circuits have expressed differing views on 2 different policy questions regarding the application of the undue influence enhancement. First, whether the undue influence enhancement can apply in a case involving attempted sexual conduct, and second, whether the undue influence enhancement can apply in a case in which the law enforcement officer poses as a minor. Now, the Commission amended the appropriate application notes in each guideline to clarify the application of the guidelines on both of these policy questions. So regarding the attempted sexual contact, the Commission clarified that the voluntariness of the minor's behavior may be compromised without the prohibited sexual contact occurring. So therefore, the enhancement will apply in cases involving attempted sexual conduct. Now, as to the second issue of the application of the undue influence enhancement, that is, in cases in which the undercover law enforcement officer poses as a minor and is the only minor involved in the case, the Commission has clarified that the undue influence enhancement does not apply in such circumstances. The Commission has determined that the undue influence enhancement should not apply in these cases because unlike other enhancements in the sex offense guidelines, the undue influence enhancement is properly focused on the effect of the defendant's actions on the minor's behavior. So when applying these guidelines, if you are in the 6th, 7th, or 11th circuits in particular, please be sure to look at your relevant case law regarding this specific offense characteristic to determine if these amendments are going to be clarifying or substantive for your particular circuit. So be sure to check your case law when you're applying the guidelines in this particular area.
Thanks, Krista. The last amendment that the Commission addressed involving case law issues is in the area of counterfeiting, and specifically the guidelines at 2B5.1. The issue that the Commission resolved centers around that of bleached notes. Bleached notes are genuine U.S. currency that are stripped of their original images through the use of solvents or other chemicals and then reprinted to appear to be notes of higher denomination than originally intended by the Department of Treasury. Now, circuits have differed on how to treat offenses involving these bleached notes, whether or not they should be sentenced under the fraud and theft guideline at 2B1.1 or whether they should be sentenced under the counterfeiting guideline at 2B5.1. And the Commission resolved this conflict by saying that offenses involving bleached notes are to be sentenced under the counterfeiting guideline at 2B5.1. Now, you will see specific language that was added to the specific offense characteristic at B2B. There's an additional subsection that provides for a 2-level increase if the defendant possesses or controls genuine U.S. currency paper from which the ink or other distinctive counterfeit deterrent has been completely or partially removed. So this addresses that issue of the bleached notes and provides for that 2-level increase. Additionally, the Commission, in making this clarification, amended the definitions of counterfeit to more closely parallel the statute. So that's also something to be aware of at that guideline. You know, as many of you who deal with these counterfeiting cases know, with the advent of technology, counterfeiting offenses themselves have changed dramatically, just even in the last 10 years. It's much easier to produce passable, if you will, counterfeit instruments than it had been, you know, 15, 20 years ago. And so the Commission felt that it was no longer appropriate to treat differently defendants who create from scratch, if you will, counterfeit obligations versus those defendants who start out with a genuine instrument and alter it through bleaching or some sort of other process. So that was kind of the thinking behind that.
All right. Thank you, Rachel.
Sure.
There are just a few of miscellaneous and technical amendments
Before we get to questions?
Before we get to questions, that I would just like to bring to your attention, bring to our viewers' attention, just so that you're aware of some potential changes that you may be dealing with post-November the 1st. The first thing I would like to mention is that Appendix A was amended to provide guideline citations for various new offenses. We've talked about some of those throughout the broadcast today, and this is something that generally happens most amendment years when we get new statutes that we need to provide references for. Also, please note that in the guidelines at Chapter 5, Parts B and D, which are the sections addressing probation and supervised release, there have been some changes made to reflect amendments that were made by the Judicial Administration and Technical Amendments Act of 2008. And that act amended the probation and supervised release statutes. So there are some changes in those particular sections regarding the conditions of confinement for the purposes of probation and supervised release that you'll want to make note of. And finally, the last miscellaneous amendment I'd like to highlight for you all is that the child pornography guidelines have been amended so that the term distribution, as it appears in those guidelines, includes the term transmission, and also the term material, as it appears in those guidelines, includes any visual depiction. So just a highlight of some of the miscellaneous and technical amendments that we wanted to bring to your attention.
Thank you, Krista. Now, I know we do have one question that we received prior to the broadcast in the area of the identity theft amendments. So why don't you tell us about that?
Absolutely. The issue that we received regarding the victim enhancement provided us with this case situation. There's a defendant who works for a bank. During the course of his employment at the bank, he steals the names and social security numbers of about 250 people. What the defendant does is take those names and social security numbers, gives them to his co-defendant, who then in turn applies for fraudulent credit cards using their names and social security numbers. He attempted to obtain the fraudulent cards. I'm not sure he was successful. There was no information about whether he was successful in obtaining them or not. Mm-hmm. However, the question is, how many victims are involved in this particular offense? Now, when we look at the victim table that provides the 2, 4, 6 level increase, depending upon the number of victims, we know that it's always been defined as a victim being a person who suffered any part of the actual loss. There's no information in this case saying that any of the people whose names or social security numbers were taken, that they suffered any actual loss. Mm-hmm. We know that there was no bodily injury that resulted from this offense. So prior to November 1st of 2009, probably not 250 victims in the application of the 2B1.1 guideline. However, because of the new amendment that we discussed regarding the definition of victim in means of identification cases, and names and social security numbers are both means of identification. So we have a means of identification case. In those particular types of cases, victim is now defined to include any person whose means of identification was used unlawfully or without authority. So their means of identification in this case was used unlawfully to try and obtain fraudulent credit cards. So effective November 1st, 2009, there will be 250 victims in this particular case.
Right. And the only other thing I want to add to sort of bolster that is to remind people that yes, the victim applies in the cases you just described, but it's still also any cases involving actual loss. This is in addition to what was previously considered a victim, which is those cases involving actual loss. And again, you can see if there's no actual loss, but you have the misuse of personal information or means of identification, don't let me confuse you, I'm sorry, it can be very wide-ranging. And I think, a lot of people have had, their check card stolen or something like that, even if it's never used. That's considered a means of identification, so it could have some very broad-reaching effects.
Absolutely. And one more point I'd like to make, too. You talked about the new specific offense characteristic B15, about the unlawful dissemination of personal information. Now, we don't have a whole lot of information about this particular question, but it's possible that in these means of identification cases that there will be this dissemination of personal information. So B15 may come into play also, that new specific offense characteristic.
Very good point. A lot of overlap in these types of offenses with the specific offense characteristics and the conduct that you see. Okay, so let's kind of recap what we've talked about today. First, we just started out with a discussion of the Commission's amendment process. Then we got into a little bit more specific discussion of amendments as they relate to identity theft, the drug offenses, those amendments that the Commission passed in response to congressional legislation, and of course amendments addressing case law issues. And then Krista summed it up for us with the miscellaneous and technical amendments that were made this past amendment year. We've had the opportunity to address at least one question. If others of you have sent in your questions, we will certainly respond to you as in a timely fashion as possible. We want you to be able to make sure that you get your questions answered. Now, with today's broadcast, as well as with a lot of the live training programs that we do, we know that the audience can represent a wide range of knowledge and experience. And so today what we hope we've done is provided you with a very general overview of the 2009 amendments. Again, if you have any additional questions as you're going through in the next year in your sentencing, your guideline application, issues that come up, feel free to contact us on our website or to look at our website. There's a lot of good information on our website. That address is www.ussc.gov. And of course, you can always call us on our helpline. That number is 202-502-4545, and we'd be happy to help you with any additional questions that you may have. Well, that's just about all the time we have for today. We thank you for joining us, and we hope you have a wonderful afternoon.